We should quickly talk about how the thing started.
Where we are.
Basically, what we're trying to achieve with what we're publishing. We'll talk about the specific skirmishes and battles that we've enjoyed with the Return Legal Services Board. You obviously came into the dispute a little bit later.
That's right.
I had been the object of the Legal Services Board's infatuation for a little bit longer. My contentious relationship with them started because I had businesses that were involved in digital matters and we were using a number of firms. I was very involved in the litigation. The most important thing from my perspective was preventing people from cheating. You can't really have a contest according to the law if some people are breaking it or not playing by the rules. I witnessed a lot of lawyers acting contrary to what the conduct rules require them to do. What got me interested in going after the Legal Services Board was that they weren't investigating my complaints against lawyers. Peter Kennedy from Magix was a good friend. He would tell me that they do what they want to do. I really didn't understand that because public officials, they're fiduciaries. I couldn't understand what he was saying, but then I started learning more. The first complaint that I had outside of them not investigating my complaints was when a current affair comeback implied that because I was dictating the letters that were going out from lawyers that my businesses were contracting, I was engaging in unqualified legal practice because I had been the source of the content of the letter. Anyway, he went to the Legal Services Board. They can't talk about anything under the public sector communication guidelines unless it's in the public interest. So this asshole, Howard Bowles, basically gives them a comment that, this is a very serious thing, we're investigating and blah, blah, blah. I don't even know why they named me. They're not the fucking lawyers. This was in 2021. Before that, I didn't know whether I had a basis to sue them because they weren't investigating my complaints. I was obviously very frustrated for some time, at least a couple of years, that they weren't investigating things. It is a waste of time and resources for people who are making the complaint. Anyway, when he did that, I knew that I had a way of going after them because they had given the statement and it was defamatory. I was in the process of setting up a law firm. Before that, we were using external lawyers as in-house counsel. That's how the thing started. The first lawyer that was hired to set up the incorporated legal practice, Ronald Gordon, turned out to be fraud in the sense that he represented that he was partly knowledgeable, but more importantly, extremely dedicated to learning about the stuff that I was doing in terms of administrative law. Really not interested in learning about administrative law and also didn't know anything. His job was to go after the Legal Services Board. He drafted a letter of demand, which I never fucking let him send because it was so embarrassing. After a few weeks, I had to tell him that it's not that I hate the government officials, particularly because they work for the government, it's because they don't fucking do their job. And in that sense, if he works for me and doesn't do his job, then we're gonna have a problem. I told him that in more menacing terms. I told him that I would sue him until the end of time. So if he breached his contract, I tried really hard to motivate him in every way. And when it didn't work, I knew that it was not an option for him not to do his job. He had the bright idea of stealing some files and giving them to Kuchiara, probably for a few cents. Then he went to the Legal Services Board and told Bowles about the fact that I was going to sue him and that I really fucking wanted to do everything that I could to teach him a lesson. Then the Legal Services Board was basically mesmerized. They wanted to fucking get me for all sorts of things. That day when Ronald Gordon stole files from the office, he was caught on camera, he was fired. The only other lawyer who had a principal's practicing certificate was Alan McGregor, who was fairly old. He was hired just to help with the costing matters. He'd actually applied for a paralegal position and a junior lawyer position at the same time. We only wanted to use him for the costing thing. He wasn't hired for a position like the one that he had to step into. So when Ronald is fired and takes over overnight, he had dementia, which we didn't know about. This was in July. Alan was very coherent all the time, basically. But he couldn't remember things. Now, with old people, that is generally an issue. I didn't have any experience with this sort of thing. I couldn't even suspect that it was. Plus, what do you do if you start suspecting that you can't make them take a test? While we were looking for a lawyer, Alan would do some silly things. So we had made a complaint about him. He had written to the judge's chambers to inquire about something because he was ill and wasn't at the office. He wanted some orders that were made, but he hadn't asked us before checking with the judge. His phone was not accessible, so we wrote to the legal service report and we said that we were concerned about the fact that he had written without checking. Then they told him that they were investigating our complaint against him. So he better fucking cooperate or he loses his license. Then they told us that, so you're saying that he's not working now. And what are you doing about it? When are you getting the replacement principal? We hadn't said that he's no longer employed. What we had said was that he hasn't been to work for some time because he was ill, like a couple of weeks or so, and he had written to the judge and so on. Now, it's not just like we were using a technicality that he was still employed, it's that he wasn't supervising anybody anyway, because when we had dates, if it was my matter, I would just self-represent. And if it was a company matter or whatever, we would just get a barrister or a solicitor to represent who was capable of representing on their own, because if it was a solicitor, they had a principal certificate. If it was a barrister, they could obviously address the court on their own. So there was no practical or principal breach of any legislation. If there had been, they would have done something about it, obviously, because we were transparent. They represent to us that we need to get a lawyer and blah, blah, blah. Then we did get a lawyer. He hadn't told us that he had an issue previously. So he told us that he was returning from holiday in Greece, and that's why he didn't have a practicing certificate. It had one issue, which I don't think was huge. He didn't tell us that until after he got hired, when he applied for his practicing certificate, and then immediately gave it to him. In any event, it wasn't a huge thing, but we knew that they were trying to go after us because Gordon had told Bowles about the thing that I was preparing against him. We told him that it wouldn't even help his case with the renewal of the certificate if he basically hung around. So that's when we contacted you, and
when I came on board.
I think they must not like you very much because they got worse after that. Essentially, then Elon was appointed unlawfully, and then we've recently.
That was
Alice, yes, she's been doing it with everybody, which is why we want to get this out so more people can come forward and help us. I was going to say fight their heads at Federation Square, but metaphorically. The point is that later that year, in the annual report of the Legal Services Board and Commissioner's Office, they clarified that Alice Duggan's delegation had been revoked. And again, very fucking misleadingly, they basically implied that it was because she had changed her job title. When the delegation was made, she was manager of compliance regulatory function, and now she was the manager of investigations. I don't understand why that would require her delegation to be revoked.
It seems to me like it was a cover-up.
Yes, they were counting on the fact that lawyers only read things when they're paid. That's the other thing that I really hate about the legal profession, or the concept of it. This is the sort of thing that you need to pay attention to in every detail. They have a very short memory and they have shorter attention spans. They glance through things superficially and then they pretend, it's in the client's best interest because we charge them less and so on and so forth. It's a system that is designed to be corrupt because of the way it's engineered. That's why, again, machines would be a welcome change.
So, what we're saying is that the Legal Services Board knew they were.
Yes, and to clarify, Regulation 65A says that people who, after their delegation, turn out to be grossly incompetent, or it's later revealed that they've committed some offense, or they commit fraud or whatever, their delegation can be revoked by that authority. So, Duggan who had been a delegate of the Victorian Legal Services Board, and pursuant to that delegation had appointed Nailon. Her original delegation was revoked. So obviously Nailon was revoked. So anybody who's been investigated by Nailon in 2022 at least, or anyone appointed by Alice Duggan, should reach out to us because we're charging them with contempt for perversion of the course of justice and we need evidence. They obviously have maintained the facade before the court, and recently at a hearing where they were trying to prevent us from releasing the information we would release, the Legal Services Board's lawyer, Jared Heath of Westcott Chambers, swore an affidavit that Matthew Addisey had told him that Nailon had been appointed by the Legal Services Commissioner. Again, for context, Nailon had been appointed because the board initially told us that because we had been a few days late in hiring a principal solicitor, even though by then we had hired Peter, they wanted to still carry on with the investigation. When we got his appointment certificate, it turned out that he had been appointed long before. It had nothing to do with the excuse they were making, and he had been appointed only to check whether Alan McGregor was senile. The odd thing was that he couldn't have been appointed because the provision he was appointed under can only be invoked if there's a consumer complaint or a formal referral by a judge. Neither had happened, and we didn't have a trust account because I was the only client and my related entities were in the sense of the Corporations Act, and there was no need to have a trust account. So basically, Nailon contacts you in December.
Right.
So you came on board on the 10th of December, and he contacts you shortly after. And what did he say? You should poison my water or something more religious? No, I mean, in seriousness, do you want to quickly summarize what the discussion was?
Yes, certainly. The discussion that you were referring to with
Not yet.
Alan was fairly brief in that he was wanting access to the company files.
Which he knew that I, as the client, had refused. So he had first asked us for access. We had asked him to fuck off.
Firstly, as you said quite correctly, you were the client. Now, what were those files? Those files that he was after were basically the
preparation for the suit against them.
That's right, preparation for the suit against the LSB, which included the issues regarding appointments, etc. The other matter was the Channel 9 matter, in which you had been defamed by Cucciaro. There were no external clients, it was you, and they wanted to see the files that are involving them.
Not just that, but also get details of every barrister that we had spoken with. Why would we tell them who we are briefing to sue them? And every barrister, every document that had been prepared, I mean, it was just, they also wanted to know everything about related entities that were not law firms and everybody involved in them. I think at some point in time they wanted to harvest Maria's eggs as well.
Yes.
I'm kidding, of course, but the point is that it was just unnecessarily intrusive. It was a joke. It's like they knew what they were doing was unlawful, so they might as well go big. Again, we didn't think anything of it. We basically wanted to engage with them, and what we decided was that we would be courteous and see what their demands were and try to reason as we moved along, and hopefully we would basically lodge the case soon. The problem was that I knew that there was stuff that was going on, and I wanted to gather forensic evidence against them, but it was impossible to do that based on the way things were because they hadn't taken an explicit detrimental action against us. I knew that if I sought preliminary discovery or other things, there would need to be a basis for it, and so I knew that I had to provoke them further or do something that would change the equilibrium to them doing something that I could seize on. So I kept creating tremendous pressure, and also, again, separately from the firm, implying that they were impotent, which they are in the circumstance that we were operating in the sense that we didn't have a trust account, and no judge had found anything wrong about what we were doing. I was the client and I wasn't going to complain about people that were doing their job. So they were fucked from the legislative perspective, and I would try to make it very clear to them as unpleasant.
But we also need to mention that very coincidentally, around about that time, this is when the police matter arose.
Yes, they basically incited the police to. So I was suing Kuchiyar for defamation. He had the bright idea that if I get charged for the defamatory stuff that he had been saying about me, then that would get rid of the thing. And it did disrupt my defamation suit against him at the time, because basically we got distracted by the police stuff and we couldn't continue with it at the time. Then I knew that the statute of limitations would mean that I have until August this year to resume the thing or to commence a new thing, because things have happened since then and I want to use the exhaustive account rather than the first one. He basically told the police that my employees that he had been paying to solicit information had told him some stuff. Anyway, that's a different topic for discussion. Those police officers are being investigated by the IBAC for criminal perversion of the course of justice and misconduct in police office. After I sued the IBAC into doing it, they had initially not cared about the fact that those assholes had been caught on record fantasizing about killing me and taking all my things as their own. But the point is that the Legal Services Board intimately fucking involved in that and issues a statement by relying on information that they got in breach of the harm undertaking. So the police applied for a search warrant after lying on affidavit that I was a criminal with an extensive criminal record, secure in the knowledge that I would never get to see the search warrant, but I was persistent. There are only so many corrupt or apathetic judges and magistrates. If you try hard enough, eventually you run into an honest one.
We need to talk about the fact that the reason why we knew that they had done so many wrong things at that time was
Because
the
they
recording,
yes?
where they had confiscated
Yeah, okay.
phones.
So the recording also convinced the magistrate. The police by then had notes about how I operate because of all the years that we've been quoting each other as an institution. In my LEAP history, they had written that I record everything. The officers who came to my house to arrest me so they could remove me from my house and then go inside and look at what things were there and then apply for a search warrant based on that. First thing they did was seize my phone, which was on recording. They thought that because they were seizing it, Sergeant Naomi Burke, as stupid as she was corrupt, carried the phone on her. And because she knew that she never returned, but the recording was being uploaded to the cloud in real time, because all my data was backed up. She carried the phone on her and incriminated herself, talking about all sorts of corrupt things, and also breaking into my house without a search warrant. They told us that they had a search warrant, but it wasn't physically on them, but they hadn't even applied for one by then. All of that got caught on the recording, and that's how we got the search warrant affidavit from the court. The point is that the Legal Services Board had been instrumental in validating Kudiara's account and legitimizing his account before Victoria Police. Magistrate Williams, who I have had many problems with, even he found that it was arguable that the Legal Services Board had incited Victoria Police into commencing or maintaining the prosecution against me, which they're now being investigated by the IBAC for it, after Justice Dene thought that they had committed a jurisdiction error in not investigating the police officers who had commenced that proceeding and broken into my house. We have spoken with a large number of lawyers who've had similar experiences of abuse of authority, and in some cases much worse. The striking feature of the abuse is that it's the same small group of people that's implicated. It's Howard Bowles at the fucking root of everything. Then there's Gordon Cooper. Reminds me of the hyenas in Lion King that were with the villain lion. Anyway, Gordon Cooper, again, very much involved. Damien Nailon is the epitome of scoundrel. 4 administrative bodies. For judges, I think Justice Court and Netherlands are the market cornered for the moment. And then there's Daniel Iacono, who gets featured quite a bit, Chantel Toussaint, Matthew Anstey, the fucking rubber stamper in chief. He's there. We are charging him with contempt of court. Matthew Anstey is basically the enabler. He knew about Damien Nealon's appointment because he's got his lawyer, or the board's lawyer, to swear a false affidavit that his appointment had been achieved through a delegation by the Legal Services Commissioner. That's wrong at so many levels because Section 256 without a complaint, which is what was the case in our situation, means that the Legal Services Board has the jurisdiction and not the Commissioner. So, couldn't have been done that way anyway. But all of this means that they're aware that they've screwed up and now they're trying to manufacture alternative bases to justify the legitimacy of the appointment. Again, it will not make a lot of sense to everybody, but the point is that we're going to publish a list of ways in which the Legal Services Board abuses authority. There are a number of lawyers who we're speaking with who will give evidence about how they've been subjected to that sort of abuse. We know that these people are doing this to a much larger group of people. There's been a report by the Ombudsman that's been published.
I was just going to say, and of course I've got first-hand experience of the effect of what they have done, and it falls right into their playbook.
Exactly. I've developed this concept of shame basically in terms of evolution, a tool that makes people feel uncomfortable because what they're doing is they're prioritizing their immediate interest at the expense of something that will hurt them in the long run. For instance, destroy their standing in the community and so on, so then they feel embarrassed and shame. It's an evolutionary mechanism to stop people from doing something that may seem good immediately, but ultimately is not in their best interest. Anyway, shame is a constant feature of what we're doing because I try to use it effectively in the context in which the academics who are currently investigating corruption are developing tools like Johan Namstorff. He came up with the concept of the invisible boot of the market to basically come up with strategies to create conflicts of interest between different members of an enterprise to basically drive them to betray each other and so on. Anyway, what I'm saying is that there's a part of shame that I personally experience in all of this, which comes from the fact that I enjoy this. There's a lot of risk and stress and so on, but biologically I'm the way I am, and I like competition, and I like being committed to something where life and death is involved. I like that aspect of it. Also, I like the fact that I'm doing something important, and if I'm successful, it'll change things considerably. But my family, people like you, close to me, who supported me, the way you all have suffered, that brings shame to me when I enjoy what I'm doing. Because I know that it's not something that anybody else appreciates like I do. It's not something that you would have wanted. Also, I didn't think that it would get to this point. I did plan for those as well, but I really didn't think that they would take away your license. They didn't technically take it away, they're just not renewing it.
No, it paid all the fees.
Basically disabled your application button in the profile that you have with the Legal Services Board. But I know that it's been difficult for your family and obviously
Extremely difficult, and for me personally as well. And it seems a pattern of how the LSB operate is that they think that if they see someone has done something wrong in their view, that they then should personally destroy them, apart from maybe disciplining them in relation to that matter. They take it upon themselves to destroy them, and they do that simply by taking away their livelihood.
Why do you say if they see someone has done something wrong? None of us has done anything.
I'm talking generally, you're saying across the board they might be looking at people who've done something that may require some disciplinary action. Now, disciplinary action could be an extra continuing professional unit. And there's all sorts of, I'm saying there, the way they respond is a complete overreach, and I totally agree. I say, and I've always maintained in my situation, I have done nothing wrong. No one's made a complaint, I've not been charged, found guilty.
What I'm trying to say is that it's not that they're too strict and that's why they're going overboard. They basically let people get away with murder when it suits their interests. Joanne Jenkins was working as an unregistered sex worker, which is again something that will come out in the matter that we were publishing. They tried to stop us. They basically accepted it in communication with other lawyers and in court with us. They tried to obtain a suppression order to stop us from basically raising it in court to seek declarations against the commissioner, who knew about the matter, that she had worked as an unregistered sex worker, based on the evidence that one of the lawyers has given, which we will also discuss in the publication. She had sent him extremely graphic videos to solicit him as a client. And then shortly after, she was appointed an investigator at the Legal Services Board and Commissioner's office. And she rose through the ranks quickly, became the manager responsible for external intervention, and then worked on the case of the lawyer that she had been soliciting for her unregistered sex work, while she was also, by the way, working as a senior associate at Hunt & Hunt. She worked on his external intervention matter, destroyed his practice, and when another lawyer complained on his behalf to the Legal Services Commissioner, they said there's nothing to see here, there's no conflict of interest. And they specifically asked him to tell Thomas Lipner, the lawyer on whose behalf the issue had been raised, that if they ever raised this matter again, well, they implied that they would be charged with a bunch of things, but I think the real threat or the real idea that they were putting in their minds was that they would demonize them and try to paint them as criminals if they tried to do this. It can only work with so many people and it can only work so many times, but it's got nothing to do with the gender.
No, I take the exception to the fact that Joanne Jenkins was the one who signed off on the letter to me in regards to saying that I was not a fit and proper person.
She has a different definition of fit and proper, but yes. The point is that the commissioner does too, because she doesn't see anything wrong with Ms. Jenkins not having declared on her application for the renewal of the practicing certificate at the time that she was doing all of those things. She lied on her admission thing. Anybody else, they would hang them. They exploit the law and they basically weaponize their regulatory powers to go after people for all sorts of things that...
Predominantly sole practitioners.
Yeah, but that's not because... I think it's just because they know that the other people will be better resourced.
Oh, exactly. I agree.
It's just that they're cowards. It's not like they're prejudiced against them. But the point is that this has gone on for long enough. At this point, it's a joke for them to write stuff like they comply with public sector values and so on. It's completely irrelevant to their ability to do their job because they don't have the moral authority to tell other people that they're bringing the profession into disrepute. People have the right to know everything about their public officials. They certainly vilify everybody that they're going against and can't legitimately beat in court. So people should know about what sort of people they are, who they're voting for or who they're permitting to regulate them. So that's the spirit in which we're encouraging everybody to come forward and give evidence. This is a predatory system. It's not going to last because, for one thing, people have a natural ability to see right and wrong. That's how the species has survived for all this while. We weren't the strongest or fastest. We survived by being accurate. So we have an emotional attachment to accuracy, which we basically sanctifies the truth, and justice is tied in with it. So people can see the truth through deductive reasoning and all the other tools that they have. It's very difficult to get rid of evidence, especially after a while, after it's spread out. Finally, there are a lot of different sorts of benefits to be gained from empowering people. Legitimate benefits, sustainable benefits that are to be gained from empowering people to hold their government to account. It's something that fundamentally appeals to everybody, so you don't need to trick them into buying into the idea. Corruption is not a sustainable thing. It's sustainable as a concept that it will always exist, but people cannot reliably engage in corrupt conduct and get away with it. They have to continuously do more and more things that are wrong, and they make themselves more and more vulnerable. And if you use the right tools, you can basically get them to kill themselves in the right conditions. I use extreme examples to make a point, but the situation is that they are wasting millions of dollars quite thoroughly. They've spent in the vicinity of $5 million in matters related to me alone. And this is the beginning of the disputes, because up until now they've been making allegations and I've been collecting evidence, and now I will go after them. They've never filed a defense in the proceedings that we have initiated in the Supreme Court. What they're trying to do is they've got a corrupt judge, Justice Gorton, who is basically implicated in the phony investigations that he's hearing judicial review applications for. So he's made a bunch of cost orders against us that purely arise from recusal applications that were made against him, and he basically made lump sum orders to disincentivize the making of recusal applications against him. I'd rather die than basically legitimize his position. And again, topic for a different discussion, but the point is that they're trying to now enforce those orders through bankruptcy notices, which we had applied to set aside, but they got their friends at the registry to, again, interfere and delay the acceptance of the documents through a number of maneuvers. We have actual claims against them, almost a couple of $100,000 of property that is seized from my office, then all the defamation and stuff, which even Gordon had to acknowledge. The point is that these people need to be stopped. I don't want to make them sound any more resourceful than they are, but the fact is they have access to a lot of money. They're not strong people. They're also not very bright or well educated in the law. And that's like the worst part of all of this, that it's not even a fucking contest. They just have to fucking rig the system. Anyway, topic for a different discussion. The point is that they're corrupt and they're spreading corruption. What they do against us and what they've been doing against other people becomes institutionalized. That's how is a threat against everybody. They knew that Peter hadn't done anything wrong. In fact, in complete honesty, there's no way we would have worked for that long had this not happened, because we're so ideologically different. Even though we agree in principle on maybe 95% of the things, but I have a different demeanor and approach than you do. What really united us was that he wouldn't breach privilege, basically fabricate stuff. There are some lines that people will not cross. I've said this to Gordon and to LSB, that in China, where they don't actually teach people about privilege the same way they're taught in common law countries, people still go to jail for trying to honestly defend their client, because it's such a human thing. It comes from the concept of fiduciary, which is basically an obligation of the soul. You don't have to teach people that. It's social contract theory, basically. They have continuously tried to push people to the point of not just looking the other way, but basically being complicit in their crimes. I say crimes because they are technically crimes in the sense of perversion of the course of justice. misleading the court deliberately, swearing false affidavits. All of these things basically mean that everybody who's cooperating with them now is bound to cooperate with them later on, because they're tied by the things that they hold on each other. They can never turn on each other. Gordon and all the other people, once they're implicated in things like this, they have to continue. That's the nature of corruption. And that's why it can be predictably used to get people to end the way of the jailer Shawshank Redemption. So everybody should come forward and give evidence and regulate their profession better.
Agreed. As one solicitor said to me, you should send out all this information and on the front in big red letters saying this could happen to you.